For those who have already joined us, welcome to the Holland Hart Immigration Seminar on H-1Bs. We're going to get started in about 1 or 2 minutes. I'm just waiting for additional attendees to join us. Thank you. All right. Welcome, everyone. I'm Roger Tsai, and you will also see we have Sarah Belletti, one of our associate attorneys at Holland Hart, joining us for our immigration webinar on immigration visas for high-tech workers, electronic lottery registration processes. We recognize that many of you may be experts at H-1B processes and others may have never heard of H-1B processes. Often, if you are an HR manager or a recruiter, you will come across the immigration process within the I-9 process, and you may have new hires that indicate they need H-1B sponsorship. So we're going to be talking about all those things today, including what is an H-1B? What do you need to do within this registration process? Why is there a registration process? Who would be eligible for an H-1B? So we're going to go through those things. Just as a brief introduction, Holland Hart, we are a law firm based in Denver, Colorado. We have about 500 attorneys. Sarah and I lead the immigration practice group, and we work with a wide variety of companies, generally focused on either healthcare or tech, but also including other areas such as mining and finance. So we are going to begin diving into the material here. I recognize that some of you may be here to listen to kind of what changes, updates, and developments there have been within the H-1B space, and we'll tackle those as well. Let's see, Sarah, if you could advance to the next slide here. Perfect. So we're going to talk about how does this lottery work. In the past, 2020, 2021, there were multiple rounds of lottery selection. In 2022, that was less true. And so we'll talk about what that means and sort of the implications for the immigrant applicants. We'll talk about sort of the approval rates and kind of the scrutiny that exists right now within the Biden administration. We'll talk about kind of the impact of remote work, COVID, on H-1B petitions. Certainly, you may have immigrant employees who may be moving from one state to another or from one county to another, and that certainly may trigger obligations that you as an employer must take. And anyways, we want to make sure that you're aware of those. Right now, tech industry is obviously going through a lot of layoffs or reduction in force. And so that also will trigger employer obligations to notify the immigration agency of early terminations of H-1B applicants. We'll talk about various compliance vulnerabilities. Often within kind of the employer's interests, it's often to get somebody onboarded as quickly as possible. But we also want to talk about the compliance and legal issues related to sponsoring individuals for H-1Bs. There's also been discussion about potential filing fee increases, and Sarah's going to tackle those in a bit as well. So just as a broad general introduction here, I recognize that most of you understand kind of what it means to be a U.S. citizen. Those are typically individuals who were born in the United States or naturalized or basically went through an application process with the immigration agency. So those individuals would typically hold a U.S. passport. While it is possible to renounce U.S. citizenship, that's quite unusual. The next sort of tier of immigration status is that as a permanent resident or a green card holder. So those two things mean the same thing. The immigration agency just released a new permanent resident card. And so typically permanent resident cards are issued for a 10-year period of time, and they can be obtained through employer sponsorship or sponsorship through a family member who happens to be a U.S. citizen or permanent resident. Typically, individuals who hold permanent residency have an unfettered right, unlimited right to work in the United States for any employer that they wish. The last tier here is that of kind of a lesser known sort of category, non-immigrant workers and visitors. So this is the alphabet soup of visas. Includes everything from H-1Bs, J-1s, F-1s, TNs. So the idea here that you should keep in your mind is anytime you hear this sort of letter plus number concept, that is probably a short-term visa that may be for a couple of years. It may present the opportunity to work, but there may be rules around who you can work for, what position you can hold, the salary that you have to be paid, and like even the location in which you perform that work. So there's all sorts of different rules centered around those specific non-immigrant visas. And to the right, you'll see this is kind of an older form. It's called an I-94 arrival departure record, which indicates somebody was in L1 visa status. And then you'll also see a temporary work permit, or also known as an employment authorization document. And so both of those are temporary in terms of the nature that they allow somebody to work in the United States. That is the category in which H-1B workers fall in. There's numerous sort of rules that pertain to H-1B workers. Next slide. So just kind of the bigger picture here in terms of that last category, temporary workers or non-immigrant visa workers. We've got H-1B workers that constitute about a quarter of the folks who enter the United States. We have L1 intercompany transfer workers. That typically applies if you have an office location outside the United States and also in the United States, and you're trying to transfer either a managerial executive worker or specialized knowledge worker in the United States. So that can be a possibility for many international organizations. E-visa treater traders and treater investors. Those are for typically foreign companies that are making substantial investments exceeding $250,000 in the United States who want to bring, quote, essential workers into the US. H-2B in the orange here. Those are seasonal non-agricultural workers. These can fall within the construction realm. It can be in the hospitality or the ski industry. Typically, those are limited to 66,000, which is split between a winter and summer season at 33,000 apiece. The other various categories, TNs, O1s, J1s, are a bit more unusual, and they once again come with their own rules. Some of these are align with obtaining or pursuing the path of a green card, and others are not. And so anyways, that's something also to be wary of and aware of. Next slide. So the basics of the H-1B. So the full sort of name here is H-1B Specialty Occupation Worker. And so the great things about the H-1B and why it probably pertains to maybe 80–90% of the individuals that we work with is because it can be used for an immigrant of any country of origin. There's no per country limits, and it may be a good long-term option for Indian and Chinese nationals who are unusually backlogged within the green card process. The period of which they are issued this H-1B visa is 3 years initially, and it can be extended up to 6 total years. Individuals can seek extensions beyond 6 total years if an employer has initiated a green card process on their behalf. This also aligns well with an immigrant who is seeking a green card process, typically through a process known as the PERM process. It can also be used for any industry and a wide variety of occupations. Typically, the litmus test here is whether or not it requires a bachelor's degree in a specific field. So a lot of the jobs here, software engineering, data analytics, fraud analysis, finance, accounting, legal, marketing. If the position requires a bachelor's degree in a specific field or major or a cluster of majors, and the immigrant themselves holds a bachelor's degree in a relevant major, that is typically going to qualify potentially for an H-1B visa. H-1Bs are eligible for premium processing, so that's an additional $2,500 fee where you can get a quick decision in about 15 calendar days. That's sometimes been available for the H-1B cap lottery process. Sometimes it has not. But typically, anyways, this is a fairly quick onboarding process, and we'll talk about kind of the logistics if you're trying to hire an H-1B lateral employee as well. Next slide here. The
Thank you. I can talk about
challenge of the H-1B visa. Sarah, if you want to address kind of the challenges.
Sure, I can talk about that. Before I jump into that, though, I wanted to respond to a good question we received from one of the attendees, because it's kind of fits well in here. The question was, I understand that the topic is specific to high-tech workers. Will you be able to touch on whether most of the concepts apply to manufacturing and engineering candidates, such as electrical engineers? It's a great question. So the answer is essentially that yes, the H-1B category could apply to these sort of individuals as well. The test for whether or not they will qualify for an H-1B visa is whether or not the position that they're filling with the employer requires a bachelor's degree at a minimum, and whether or not that individual has a bachelor's degree in a closely related field. So electrical engineer would almost certainly qualify for H-1B visa, because I'm sure a bachelor's degree in electrical engineering would probably be required to perform the role, and the individual would likely have a degree in electrical engineering or maybe something closely related. I, in my former role, worked with the US auto companies quite regularly, and they had scores of individuals in H-1B visa category in electrical engineering, mechanical engineering, computer engineering, materials engineering, all those sort of fields. So where it becomes more challenging is if it's a role that's more like computer analyst or something that may not require a bachelor's degree for entry into the role. Let me know though if that didn't fully answer your question. Thank you for the question. If other people have them, please, by all means, put them in the chat and we will respond to them as we can. In terms of the kind of downsides of the H-1B visa category, the main thing is that each year they're numerically limited. So by statute, each year the US government gives out 65,000 H-1B visas with an additional 20,000 that are reserved for individuals with a US master's degree. So the way the H-1B cap lottery occurs each year is that between the first couple of weeks of March, this year was just announced that the registration period will be March 1st through March 17th. Employers will put in the registration lottery any employees they want to obtain an H-1B visa for in that fiscal year. For last year, for 2022, there were over 480,000 registrants and inserted in the H-1B cap lottery for a total of 85,000 H-1B visa slots. So the percentage chance of being selected was fairly low for last year. It was about 15% for the regular bachelor's cap and slightly higher, closer to 20% for the US master's cap. This year, we anticipate that the percentage chance may be slightly better. There may be slightly less applicants in the lottery this year based on what's happening in the tech industry and some of the layoffs and the reduction in force, but we won't know until months later what the actual total number was of applicants in the H-1B cap lottery. In terms of the electronic registration process, started to touch on it a little bit. So the old system prior to 2020 was that on April 1st, employers had to submit full H-1B petitions for anyone they wanted to register in the cap lottery. Usually within a week time frame, they would collect these applications and then run the lottery, and they would keep any petitions that were selected in that lottery process and reject or send back the full petition for anyone who wasn't lucky enough to be selected in the lottery for that year. So understandably, it created a lot of work, a lot of sort of anxiety for employers and immigration lawyers, because we were trying to complete full H-1B petitions for anyone that was going to be entered in that year's cap lottery to be filed usually between April 1st and April 5th. In 2020, United States Citizenship and Immigration Services rolled out a new process where they conduct instead the lottery based on online registration that is submitted. The window for the registration this year, as I said, is going to be from March 1st to March 17th. But it closes at noon on March 17th. So at that time, at that cutoff, all registrations have to be submitted for anyone who wants an H-1B cap visa in fiscal year 2024. Then United States Citizenship and Immigration Services will conduct the electronic lottery around March 31st and start communicating the results and who is selected through the online system, which is essentially an online platform. So all immigration attorneys have created their own account, and each individual HR representative at the various companies who are applying for these registration spots for their employees also have to create an account, because there is a part of the registration process that involves like what they call a handshake, where we have to put in the information that's required in the registration, and then the HR representative has to log into their account and verify that the attorney is in fact representing them and that the other information is correct relative to the employee. And only through going through that process is the attorney then able to submit the registration. So that's sort of the pain point of it, but it's still a lot better system than what we were working with previously, because the level of information that's required up front is far smaller.
Sarah, if I could I add, this registration process, it's about 3 or 4 years old now. And while it's relatively stable, I guess as an employer, if you're trying to do this on your own, I would just be careful. One, you need to register as a registrant, not a participant. If you do, then as a registrant, that will allow you to actually register. You're not actually required to use an attorney if you choose not to, and certainly you don't have to have an attorney to go through that process. The other thing I would mention, the amount of information, the data points that are necessary for the registration itself is quite low. So certainly employer name, immigrant name, a lot of passport information, biographical information, does not require you to insert, for example, salary, does not require a job title. And essentially it's the bare bones sort of information for the immigration agency to detect if there's fraud occurring, if there's duplicate entries occurring. So anyways, those are some considerations. One last thing I'll add, I noticed that there's some universities that are also participating. This lottery process that we're talking about, it does not apply if you are, quote, H-1B cap exempt. So there are a wide variety of organizations that are exempt from this H-1B lottery, including academic institutions, universities, healthcare research institutions that may have affiliations with universities as well. Also, if you're sponsoring a J1 physician, you're also exempt from this H-1B lottery process as well. Turning it back to you, Sarah.
Thank you. So yes, as Roger just sort of alluded to, the amount of information that's required to submit an H-1B cap registration is fairly low. From the employer side, what's required is essentially the legal name of the company, the FEIN, the primary office location of the employer, and the name, title, and contact information for the signatory. From the beneficiary, what's needed is really just their full legal name, their gender, their highest degree attained, whether that's a bachelor's, a master's degree, or above, their date of birth, their country of birth, and their country of citizenship and passport number. So for the registration process itself that occurs between March 1st and March 17th, we are not required to file an LCA, a labor condition application, and we don't even really need information about the proffered position because it's not required by the registration. That said, I think our practice is to review some of that additional information about the proffered position to sort of screen to ensure that the individual who's being registered in the CAP qualifies for an H-1B visa and they have education that corresponds to the position they're going to fill. Because we're trying to make sure that the individuals that are registered in the CAP, if they are selected, we can file a successful H-1B petition on their behalf. Because USCIS is monitoring if employers selected for the lottery actually go forward and file an H-1B petition to avoid abuse. Employers may not submit more than one registration per foreign national. However, different corporate entities within a group or a corporation umbrella can submit more than one entry per each corporate entity as long as there's a bona fide job offer for the individual that corresponds to each of those registrations. So that's something to be a little careful with, and that is definitely something that USCIS is monitoring. I think in the initial year or two of the H-1B cap registration process, some of the largest tech companies were trying to game the system a little bit by filing multiple registrations through each corporate entity that they had. And that was definitely looked at by USCIS and is strongly discouraged. So you don't want to end up in a situation where USCIS bars you from filing H-1B petitions in the future due to these sort of practices. Once the H-1B cap lottery results are announced around March 31st, April 1st, employers are then given 90 days to file H-1B petitions for the registrations that were selected. So that filing deadline is usually June 30th of the given year. In the not last year, but in the years prior to that, there were additional rounds of cap lottery selection after the April 1st big round. In 2021, there were actually 2 additional rounds, one in approximately like late July, early August, and then another one in November. Those were much smaller rounds. The chance of being selected in those later rounds, if they occur, is much, much lower, like probably 1% or less. Because really what's happening there is the government realizes that not everyone who is selected in the initial round is moving forward with filing the H-1B cap petition. So they conduct additional rounds to get to the full 85,000 total available H-1B visas. In 2022, there were no additional rounds because I think USCIS has sort of honed in on what the right number is to select in the initial cap lottery in order to fully fill those 85,000 visa spots.
So I'll just kind of underscore something that Sarah mentioned that's quite important. If you as an employer accidentally submit on behalf of one company 2 different registrations for one immigrant employee, both of those registrations will be thrown out and effectively you'll have lost the sort of opportunity to file on behalf of that person. So certainly that's something to be wary of. The other sort of finicky part of this, within this lottery, there's 2 categories of grouping. So there's 85,000 total H-1B visas that are being distributed, but 20,000 are in a master's degree cap group. So you have to select whether or not this individual is a U.S. master's degree individual or basically in the bachelor's degree grouping. If you get this wrong, it could be very problematic. As you can imagine, for example, if you had placed somebody in the master's degree group who doesn't actually hold a master's degree master's degree education from the United States, that would lead to basically denial at the I-129 process of this. So we've talked about basically kind of step number 1 thus far. So that's the lottery registration. So that's going to happen from this March 1 to March 17 date. USCIS has confirmed that time frame. And then as Sarah mentioned, part 2 is basically filing about an inch-thick stack of documents, often kind of including educational documents and immigration documents for the immigrant applicant. I just want to mention, many firms do this, but we offer sort of a choice here as to whether or not you'd like us to kind of prepare both parts of this application process, specifically it's known as the I-129 petition. If you'd like us to do that before the lottery results are announced, we call that priority preparation, or if you'd like us to do it after the lottery results are announced, which is regular preparation. I would indicate that for most immigrant employees, regular preparation is going to be perfectly fine. There are some select individuals who perhaps have their OPT or work authorization status expires in maybe April or May, and it is particularly important that those individuals and their I-129 petitions are filed as quickly as possible because they will get the benefit of something called the H-1B cap gap regulation. So we'll talk about that in a bit further here. But in short, there's 2 sort of modes of preparation. One that kind of focuses on getting that I-129 petition filed as quickly as possible, priority preparation, a little more cost upfront. And essentially we're doing the work and therefore, anyways, it's the full legal fees, regardless of whether or not somebody's selected within that process, charging it at $4,000. Sarah, would you mind advancing to that next slide? And under regular preparation, essentially we're charging clients $1,500 for the lottery selection process, and then $3,000 if, it's an additional $3,000 for the I-129 petition process once that goes through. So that's that April to June timeframe. If you're seeking to kind of keep this at the lowest cost level, regular preparation will be fine for most employers and immigrants. Next slide here. So I want to kind of give you a flow chart of how a new H-1B worker typically kind of approaches an employer or kind of encounters an employer. So typically you'll have somebody already in the United States. They're an international student graduate, could have graduated from a bachelor's degree or a master's degree from a US university. So these individuals are automatically given a 1-year OPT or work permit. If they've graduated in a STEM field, then they will get an additional 2-year STEM OPT. That is something that they would affirmatively have to apply for through the immigration agency. So these individuals during this 1 to 3 year period of time, they need to find kind of their next sort of immigration status and opportunity. Typically, that's going to be an H-1B. So the employer is going to submit an electronic registration on their behalf. They can submit this year in 2023 and 2024 and 2025 multiple times if they'd like. If they are in fact selected, and as Sarah mentioned, that will be announced around March 30th, I'm sorry, 31st. If they are in fact selected, then there's an I-129 petition that is submitted to the U.S. Citizenship and Immigration Service. So that's the Domestic Immigration Agency. Typically at that point, the immigration agency is kind of considering the merits of the role. Is this a position that requires a bachelor's degree? Does the immigrant employee themselves qualify? Have they maintained lawful immigration status? If necessary, the F1 OPT, if it expires, the student can continue to work from, let's say, the expiration of their EAD expiration until September 30th of 2023 under this cap-gap regulation. The results of the I-129 petition will typically be announced. It could be anywhere. It says here 3 to 5 months. We've seen it take maybe possibly as long as 7 to 9 months at times. In the last year or two, the premium processing, that's an additional $2,500 fee that goes to the immigration agency, that may be available. And if it is, decision can be issued within 15 calendar days. I would say that also 10 to 20% of these cases do receive what's known as a request for evidence. Also, we call it an RFE. So these requests for evidences are basically when the immigration agency exerts some scrutiny on the case. They may want to know more about the immigrant, their qualifications, their educational history, their immigration status. They may want to learn more about the position and whether or not you've really employed individuals who are bachelor degree individuals in the role. Does this really require a bachelor's degree in a specific major or cluster of majors? Once the case is approved, an I-797 approval notice will be issued by the immigration agency. The H-1B status and the work authorization accompanying it does not actually begin until October 1st of 2023. That's basically the start of the USCIS fiscal year. So it's October 1st. If the USCIS has approved the application, if they have not approved the application, then obviously will be delayed until an approval is issued. Sarah, did you want to add anything to that?
I think the only thing I would add is that in terms of assessing potential entrants for the H-1B cap lottery in a given year, the individuals that are in F1 student status working on OPT or CPT, I would say make up the majority of the employees that are entered in a given year in the cap lottery. But there are other employees that would likely be wise to consider, and they may be in other non-immigrant statuses such as TN, such as L, E. So those individuals, it would be more a case-by-case basis to assess whether or not they should be entered in the H-1B cap lottery. But there are often advantages to having them selected and being able to transition into H status either that given year on October 1st or in the future through a petition set for consular notification at a U.S. embassy abroad.
Great note there. And I'll just take a minute. We're halfway through kind of our time. Certainly, if you have any questions, feel free to add it to the chat box. We love questions. It makes this a little more interactive and interesting. So feel free to kind of add your questions there. We'll try to address it. I mentioned earlier there's this concept of a cap gap regulation. And so the cap gap regulation, this occurs when somebody is under an OPT work authorization, optional practical training work authorization that expires sometime between April 1 to October 1 of 2023. And the idea here is as long as somebody is in good faith moving forward with the H-1B process, even though their, let's say, OPT work permit expires May 1, as long as they're moving forward with that H-1B process and have not been denied and have been selected within the lottery, they will have continued work authorization up until October 1st of 2023. There are some specific sort of kind of notes that I would make here. It can get a little bit tricky. Whether or not somebody is a beneficiary under the cap-gap regulation depends on the fact that that second step, the I-129 petition, has been submitted before that particular work permit has expired. So I gave you the example of, let's say, the work permit expires May 1 of 2023. Well, then in that instance, the employer and the law firm need to submit the I-129 petition, assuming that they have been selected within the lottery before May 1. The application must continue to be processed pending, cannot be denied. If it is denied, then essentially the underlying OPT cap gap regulation and work authorization would then cease. The work authorization only takes the individual up until October 1st of 2023. So if a decision has not been issued on the H-1B after October 1st of 2023, then the work authorization essentially stops at that point. I would also just note that USCIS has some guidance as to how immigrant employees who have this cap gap regulation need to touch base with their international student offices to obtain a new I-20 and evidence their cap gap work authorization. So that's something to pay attention to. I will also just mention that STEM OPT, the 2-year extension to regular OPT, is available. It's worthwhile if you think that you're a STEM OPT beneficiary to double check. Immigration and Customs Enforcement has a list of the hundreds of different majors that qualify as a STEM major. And so there may be some that you don't think that would qualify for STEM and do, and vice versa. But anyways, I would just double check whether or not the major that's listed on the I-20 actually qualifies for STEM OPT. I believe, anyways, typically you can apply for STEM OPT 90 days in advance of the work authorization expiration under OPT. I-765 applications, these STEM OPT work authorization applications are taking quite a while. So certainly, if you are an immigrant employee who is thinking about doing that, you want to stay on top of that and apply as soon as possible. You do get continued work authorization as long as even after the OPT has expired, as long as the STEM OPT application is pending. Next slide here. Many of you will come across this scenario, and this happens kind of throughout the year, not kind of within the H-1B lottery filing season. Essentially, this is called an H-1B change of employer. So let's say your company wants to hire somebody who recently worked at Microsoft or Apple under H-1B status. So the immigration laws have been crafted in a way to facilitate that. So essentially, assuming that the individual has not been unemployed for a long duration, anyways, the employer, your company, would submit the I-129 petition. And once that is submitted to the immigration agency, the new immigrant employee can be onboarded, can begin work with the employer. The regulations state that it has to be, quote, properly received by the immigration agency. There's some question as to whether or not that's like a FedEx UPS type receipt or a USCIS receipt. About possibly under regular processing, it could be 3 to 7 months later. A decision might be issued on the case, or alternatively 15 calendar days under premium processing. There are some immigrant employees who would prefer not to begin work with the new employer until an approval has been issued. Certainly that's not atypical to see. We do see that a lot of employers are paying for premium processing just to kind of get that certainty of an approval even before somebody begins work. As part of this process, I mentioned earlier that H-1B individuals are limited to 6 total years unless an employer has initiated the green card process. And so you want to double check how many total years of H-1B status somebody has already utilized. Certainly, it may not be the best idea to hire somebody who has been under H-1B status for 5 years and does not have any prior green card processes initiated, because then you'll be stuck only employing them possibly for 1 year under H-1B status. Next slide. And I'll turn it back to Sarah here.
Before we do that, Roger, we got 2 questions, which maybe we can address now that are kind of relevant to what we were just talking about. One is it a good option to switch jobs to a university nonprofit think tank in the case I don't get selected in the H-1B lottery? I don't know if you want to tackle that.
Sure. I think that's certainly worth considering. So I guess, anyways, the concern here is, what if I don't get selected within the lottery? There's only a 15–20% chance. So should I consider an employer who is cap exempt? I guess a couple of thoughts if I were in your shoes. One, is this employer sort of organization, are they familiar with submitting H-1Bs? Certainly, if they're not, that can be a hurdle. 2, have they ever actually filed H-1B cap exempt petitions? That would be another consideration. There are some nuances and different categories, subcategories of cap exemption. A university is a very clear-cut, anyways, a public-private university is a clear-cut example of entities that may file H-1B applications throughout the entire year. Other organizations that may be a little more tricky, nonprofit entities that have an affiliation with a university. We happen to represent a large hospital system that has affiliation agreements with a university. There are questions as to what does that mean in terms of an affiliation agreement? In our instance, it's sharing of resources to basically train everybody from nurses, doctors, and to collaborate in terms of that medical education, which is fairly strong. There's also individuals who sit on boards of both the university and the nonprofit. So those are strong ties. The one other consideration that you may want to consider to think through is, at some point you will leave potentially that cap exempt nonprofit university or other employer who's basically not requiring you to undergo the H-1B lottery. And so if you were to move to a cap subject H-1B employer, you will have to go through the cap lottery at some point within your career. There are some special rules that may allow you to transition from the H-1B cap exempt employer to the cap subject employer. But anyways, it gets into kind of some pretty nitty-gritty nuances. So those are kind of the big 3 considerations that you'll just want to give some thought to. Let's see, Sarah, did you see another question?
There's another one that says, can an F1 student that has last day of STEM OPT in March use cap gap if they register before the OPT expires?
It's a good question. So what I'm hearing is the STEM OPT expires March 31st. So essentially the day that lottery results are announced. So in this instance, they would not be a beneficiary, as far as I can tell, of kind of the conventional cap gap work authorization, because essentially the rule here is that an I-129 petition must be filed before the has to be filed before the OPT expires. So in this instance, that would be impossible, because April 1 would be the very earliest date in which you could file the I-129 petition. And so anyways, continued work authorization under cap gap from April 1 to October 1 or September 30th would not be available. There may be, I think there's an argument there, and Sarah, I'd be interested in your thoughts in terms of continued ability to remain in the United States in the interim.
Yeah, I think that for an F1 student, if you're within your 60-day grace period, either because your OPT employment authorization expired or you graduated and you didn't have OPT, I think your F1 status would continue. You would have that sort of gap coverage until your H-1B becomes effective. But as Roger said, you would not have the continued employment authorization by virtue of the fact that your OPT expired before April 1st. So while you could remain in the US until your H-1B became effective, you would not be able to work from the day your OPT expired till October 1st when your H-1B became effective.
Perfect. Thank you for those questions
Great.
and keep them coming. Sarah?
Questions, and I can turn to talking a little bit about preparing H-1B petitions for scrutiny. This is part of what we're doing, I think, from the start when we're reviewing the individuals that we're entering in the H-1B CAP registration, and even more so once we know who's selected in the lottery and who we're going to file H-1B petitions for. As we've discussed earlier in this webinar, the key thing is that the position that the employer has for the individual has to require a bachelor's degree at a minimum in a specific major or small number of majors. And the immigrant employee must hold a bachelor's degree or higher in one of those specific fields. If that's not the case, it's a much more problematic H-1B petition, or maybe not even possible to file for that individual. So the main things that we're sort of assessing and trying to protect against when we file these H-1B petitions to prevent requests for evidence being issued after filing is this going to meet USCIS's definition of a specialty occupation, and that it requires a bachelor's degree at a minimum? The other thing is, does the individual hold a degree in one of those fields? We're also looking particularly if the person has been an F1 student status to make sure that they've maintained their immigrant status, their non-immigrant status while they've held that F1 status, because there are some specific rules that USCIS has about total number of days of unemployment an individual can have in OPT status in particular, and STEM OPT status, which I think for the full 3-year STEM OPT status, it's up to 150 days of unemployment. And for the initial OPT 1-year period, it's up to 90 days of unemployment. And if the individual has accrued more days than that of unemployment, then that's something we're assessing, and it's a strategic consideration for us and how we want to file that H-1B petition, because in that instance, we would likely set it for consular notification, meaning the individual would have to travel to a US embassy, likely in their home country, and obtain their H-1B visa there, rather than try and change status in the US. Did you want to add something, Roger? Okay. One of the other things that we're assessing in terms of scrutiny is making sure that it's clear that the employer-employee relationship exists between the employer and the H-1B CAP registrant. This is mostly an issue if the company is a staffing company and they're placing employees at third-party client sites. We don't deal with that all that much in our practice. I have in the past, I'm sure Roger has too. And there are specific things that kind of have to be included and watched for if it's that third-party placement context. Other thing we're kind of assessing is the salary range, because there is a minimum wage that must be paid based on the specifics of the position and the location. And we have to make sure that the offered salary for this H-1B CAP registrant meets that minimum, which we'll talk about more in a minute. And then the final thing we're looking at is whether or not the role requires any sort of licensure or, occupational licensure. This could be a medical type role where the person has direct patient contact and maybe needs, some sort of license to perform their duties. It could be in the engineering context if the position requires a professional engineering license or something of that nature. So we're just trying to make sure that the individual meets the requirements of the role that we're filing the H-1B petition for. Okay. In terms of salary, as I sort of just alluded to, in the H-1B context, when filing an H-1B petition, there is a required wage, which is the higher of the actual wage level paid by the employer to all other individuals in similar roles with similar experience for the specific employment at the place of employment, or the prevailing wage for the occupation in the area of employment, which is set by the Department of Labor. So the Department of Labor establishes this, and we can look this up if anyone has questions about it, in terms of what the minimum wage is for the occupational classification for the specific location of the role. So for example, a software developer with a position based in Santa Clara County, California, might have a much higher minimum wage than that same role might have in, say, Detroit, Michigan, just based on the mean wage of other workers employed in similar occupations in that area. So one important thing that's definitely become an issue since the pandemic and the new remote workforce that we have to keep an eye on is that if the worker is allowed to work remotely, we have to use the higher prevailing wage of either the employer's work site where the person is supposed to be, or their home address if they're allowed to work from home all or some of the time. So for example, if the company's headquarters are in Draper, Utah, but the employees working remotely, some or all of the time from Denver, Colorado, the wage for that role in Denver, Colorado is likely to be significantly higher. And we're going to have to use that as the prevailing wage, as the higher of the two will control. The other thing that becomes important in this regard, in this post-pandemic world, is if remote work is allowed and the employee moves and they don't tell the employer right away, or they tell them like right as it's happening, that can also impact the wage level. So if someone suddenly who was working in, say, Iowa decides to move to California, an H-1B amendment petition will have to be filed, and the minimum wage for that role will go up significantly based on that new work location. There are some alternative sources of this prevailing wage or mean wage level for the role that can be utilized, such as a third-party independent wage source. I haven't used those too much in my career. Sometimes they can be useful if you're working in a particularly like high wage area, such as, you know, San Francisco or Santa Clara County, California. I think it's a little more common in those locations. But one, I think important thing is if a wage survey is utilized, you have to be prepared to provide the entire wage survey at the time that you file the H-1B petition, or certainly get an RFE from USCIS asking for that. Other thing is universities and affiliated nonprofits may use prevailing wage calculations for similar institutions. So they have sort of their own sort of rules and their own wage levels that can be looked to in that context. And the final thing is the employer must ensure that working conditions for the H-1B worker will not adversely affect other workers similarly employed in terms of their hours, the shift, the vacation periods, and fringe benefits. It's supposed to be essentially the same as the conditions of employment that are offered to other individuals in similar roles for the employer, regardless of their, you know, national origin.
All great points. And one just minor note that I would add, sometimes employers have the question of, well, can I add the bonus to help immigrant employee meet that prevailing wage? And unfortunately, that is not available or possible. Essentially, an individual's base salary must exceed the prevailing wage. And if they're working in multiple work sites, it has to be the higher of the 2 or 3 work sites. One other thing to mention is if somebody's working under OPT or H-4 work permit status, anyways, there's no prevailing wages that apply to that instance. And so this can lead to a sort of a tricky situation in which an employer may be committing to increase somebody's salary if in fact they are selected within the H-1B lottery, and that transition to a higher salary may occur after October 1 when somebody actually transitioned from that F1 OPT to H-1B status. Anyways, those are just some unusual questions that other employers have asked before. A lot of the focus of the presentation thus far has basically been to try to help secure an H-1B visa. These are kind of questions to probe. Have we done it right? Do we have the right paperwork in place? Is there a potential liability that's kind of lying within your files? And certainly if you're an employer that's just kind of in the past, you've filed a lot of H-1Bs and you're kind of uncertain as to kind of what has happened historically, these might help to elucidate challenges that you'll want to look further into. So one, are you properly maintaining a public inspection or quote disclosure file? So this is required as part of filing it's called the ETA 9035. It's also known as the labor condition application. Anytime you file one of these, essentially you have to keep a public inspection file for a 4-year period of time. We have, within later slides, included a list of the documents of what needs to be included in a public inspection file. So you want to make sure you have those. Certainly, the U.S. Department of Labor can come and audit you at any point if you have previously filed a labor condition application. Other question here, have you filed an H-1B amendment with the immigration agency when a material change in the employment has occurred? So material change might include somebody's gone from an individual contributor engineer role to a manager role or director type role, had a huge jump in their salary. That would certainly be a material change. Another material change example would be if somebody's moving from Salt Lake City to San Francisco in terms of work site. Certainly that would be a material change that would impact that prevailing wage that's applicable and would trigger a new labor condition application H-1B amendment. Are you ensuring the maintenance of immigration status for H-1B transfer workers? So we mentioned, like, if you're trying to hire somebody who's previously employed at Microsoft, if they've had some sort of gap in terms of their employment, let's say they've been unemployed for 6 months, that is a huge problem. From an immigration standpoint, because technically they have not been working for 6 months. They have not maintained their H-1B visa status for a 6-month period of time. Sarah had mentioned earlier that this same or similar rule applies to F1 OPT individuals as well. A 90 to 150 day time frame applies there. If more than 15% of your workers are in H-1B status, then you are considered an H-1B dependent employer, and there are additional steps that you may have to undertake to demonstrate that you are in good faith trying to locate U.S. citizen workers for your workforce. Often you may have independent high-tech contractors who are on your work site, and the concern here is not just somebody who comes to fix your printer for a day, but rather somebody who might be on site and managed by one of your employees, maybe for a year plus. The immigration agency expects not the entity that's paying that particular immigrant, but is controlling the means and manner of the employment to file the H-1B petition. So the concern here is that you're exerting so much control over that worker that you've become their employer despite not paying them directly. In that instance, you may be deemed their H-1B employer. Employers who are considering salary cuts, that will have different implications for an H-1B worker than it will a normal US citizen or green card worker. Essentially, if you reduce an H-1B worker's salary below what either the prevailing wage or the wage that was asserted in the I-129 application, that can have serious consequences. One, you're actually technically on the hook financially to continue to pay that salary until you give notice to the immigration agencies. So you have to file an amendment. But two, anyways, you may jeopardize that particular immigrant employee's continued H-1B status. If you terminate H-1B workers, there are actually 3 steps that have to be undertaken to officially sort of informally end the H-1B relationship. 1, you have to give notice to the H-1B worker in writing. 2, you have to provide notice to the immigration agency. We can provide you a template letter of kind of what you need to tell the USCIS Service Center. And 3, you have to offer to pay the return travel, so basically a flight ticket back to that individual's home country. Most immigrant employees will choose to remain in the United States, but you want to certainly document that you offered to pay that return travel. Note that your financial obligation to continue to pay the H-1B salary continues to exist and continues forward until all 3 steps have been completed. Lastly, if you have an H-1B workforce, you want to be mindful of how many years that particular H-1B worker has left, both on their current H-1B approval, but also relative to that 6-year maximum that we talked about. You may need to initiate a green card process here pretty soon. And anyways, in short, this is a good idea for HR departments to keep track of anybody who's not a US citizen, not a permanent resident, but basically has expiring work authorization. You want to make sure that those individuals, you're being mindful of when their status expires and when their ability to work for your company ends. Next slide here. Let's see, it looked like there was a question on that last slide here. Sorry, we were originally told that it was titled public access file. No, yeah. So you can call it either, and it doesn't necessarily matter what you call it. technically it needs to be available for access if USDOL were to audit you. Yeah, we've heard it referred to as public inspection file, public access file. I missed the answer to the 15% of workers. Is it a higher liability if we do not? And I'm not sure the sort of complete question there. So in terms of if you have 15% of your workforce in H-1B status, there's additional steps that must be undertaken. You are considered what's called an H-1B dependent employer. That number, anyways, 15% does vary a bit if you're a smaller employer with less than 50 and 25 employees. So anyways, the 15% calculation does vary when you're a smaller employer. But yeah, if you think you fit within that category, having more than 15% of your workforce in H-1B status, email us later, and anyways, we can kind of walk you through that. I would also mention there's slightly higher government filing fees if more than 50% of your workforce is in H or L visa status. Sarah, anything to add to that?
No, I don't think so. I think that covers it, but yeah, certainly if you have additional questions about that specific to you, feel free to email us. In terms of termination, Roger already touched on this, but just for the sake of, I guess, redundancy, because this is an important point, and I think a lot of employers may not know about their obligations in the event that they terminate a non-immigrant worker, particularly an H-1B status. And it is really important if you separate from an H-1B worker that you notify USCIS of the termination in writing. Otherwise, you could accrue back wages for that worker. The employer is also liable for the reasonable cost of return transportation of the alien abroad, typically to their home country. We also would probably recommend that you make that offer to them in writing, like possibly as part of their, final, kind of termination notice. I will say that I think by and large, employees don't take the employer up on this. They don't typically want to return home to their home country, and instead they're usually going to look to see if they can find another employer to petition for them to change their H-1B over to that new employer. And typically when someone is terminated in H-1B status, they have the 60-day grace period as soon as their full-time employment ends in order to potentially secure new employment and transfer their H-1B visa to that new employer. The only limitation on that would be is if that employee's current H-1B visa was set to expire in a shorter time frame than that 60 days, that would be the end date. So it's the earlier of their current expiration or the 60 days from the date that their full-time employment ends. So just something to be aware of. In a similar vein to termination, layoffs and reductions in wages also have obligations to the employer that arise. I think Roger already mentioned that H-1B workers, by and large, their wages cannot be reduced. They have to be paid the wage that was offered in their H-1B petition, which could have been the prevailing wage, or it could be a higher wage that was articulated as their offered wage. And in order to reduce their wage, an amendment petition would have to be filed and received by USCIS before that change in their salary could be made. So particularly when the pandemic hit, we received, I think all immigration attorneys received that question, is that can we reduce the wages we're doing and across the board, like 20% decrease, something like that. And it was a lot of sort of disappointing conversations I had in particular with employers when I told them that for the H-1B workers, they couldn't automatically reduce their wages, even if they were doing it for the rest of their workforce without taking a further step, like filing that H-1B amendment petition. They also can't reduce their hours significantly without filing an H-1B amendment petition. You can file an H-1B for part-time work, so that amendment can take place, but those steps have to be completed before someone's hours can be reduced. A layoff or reduction of force can also have implications for the PERM process, which is the first step of the employment-based green card process. Because when that PERM application is filed online with the U.S. Department of Labor, there's a question that the employer is answering under penalty of perjury that asks whether or not any layoffs have occurred within 6 months in the intended area of employment. So essentially the question is, have there been layoffs at the same work location in a similar position to the PERM role within the past 6 months immediately preceding filing that application? And if the answer to that is yes, A, we have to say yes, we have to be truthful, and B, it almost absolutely is going to trigger an audit from the Department of Labor, because there are additional steps the employer has to take if they have had such a layoff, which is essentially they have to notify impacted workers in similar occupations of the perm role and invite them to apply for it, and then properly disqualify them. So this is something we've dealt with a little bit recently, given what's going on in the current economy, and it's just something important to note. Okay. Next, this is a good lead into talking about permanent residency. So we won't go too deep into it because this is more geared towards H-1Bs in the non-immigrant visa context. But PERM, or the employment-based green card process, is sort of the long-term planning of this whole process for employees. So if someone secures an H-1B visa, as Roger stated early on, it's usually granted for 3 years initially, and then it can be extended for additional 3 years for a maximum of 6 years. So the question is, okay, well, what happens when that 6 years is up or close to up? Like, how do we continue to employ this person past that 6-year maximum? And the answer is you have to start as the employer, the employment-based green card process for them, typically by year 4, because various steps in it take quite a while. But essentially, the employee has to go through step 1, which is the filing of a PERM application online with the Department of Labor. And then step 2, which is the filing of an I-140 petition with the United States Citizenship and Immigration Services, and have that approved in order to extend their H-1B status beyond the 6-year maximum. This is particularly important for individuals who are from a country that is backlogged in terms of having available green card numbers. So that's essentially India, China, to some extent Mexico, and Vietnam. In this year, in 2023, there has been some retrogression in the visa bulletin for some other categories as well. So I would say it's probably a good rule of thumb that for anyone that's employed in H-1B status to start the PERM process no later than their 4th year in that status at a minimum, because getting through steps 1 and 2 of this green card process can take quite some time. The PERM process alone, I would say, takes around 14 months, if not a little longer, depending on sort of the specifics of the case. And then the next step, I-140, can be shorter. Premium processing is available for it to get a result from USCIS within 15 days for an additional $2,500 fee. But if you wanted to file the I-140 with standard processing, the processing time would be closer to 8 months. So that gets us to that 2-year mark, if not further, pretty quickly. Roger, was there anything you wanted to add to that?
No, that's perfect. So let me kind of close with just, these are just some stats regarding national averages in terms of approval rates on H-1Bs and green card processes, both steps number 1 and 2 there. Just to kind of give you the latest information. We, as a team, we're taking on anywhere from typically 300 to 400 cases a year, and consistently having high success with each of these types of different cases. Yeah, I mean, at this point, we have not had a case denied, knock on wood. And certainly that is something that we care about, and treating each individual immigrant employee as a person as opposed to just kind of a number. So next slide here. Anyways, our team at Holland Hart, I think what we're really great at is kind of helping address the concerns you've got, wanting to help you get your talent onboarded as quickly as possible. So anyways, certainly we can talk to you about moving forward on the green card process. Typically, we can get cases such as H-1B submitted within about 3 to 4 weeks on H's. We care about providing individualized attention on immigration matters. So that means having a one-on-one type call with your immigrant employee, your HR team, your immigrant employee supervisor to talk about this immigration process. We recognize that, immigration may not be your day-to-day sort of focus or area of focus. And so we can help to translate kind of the issues and problems, make sure that expectations are aligned in terms of timeframes. We are responsive. I know that's often kind of a common complaint of kind of immigration firms that anyways, they're just simply not responding to the questions and issues that we've got. And so we totally get that when questions arise, they really cannot wait, whether that's an I-9 question, whether somebody's outside the United States at a US embassy trying to go through a consular interview, they anyways need to be addressed quickly. The last part here, legal compliance. As much as we'd all love to get somebody onboarded as quickly as possible, anyways, not kind of crossing our T's and dotting our I's can spell disaster in terms of future applications. Note that if an employer is found out of compliance, certainly there could be civil fines and penalties in addition to debarment from the immigration process, labor condition application process, future perm supervised recruitment. So last slide here. Here's our contact information to the extent that you've got any questions. Once again, this is kind of Sarah and our bread and butter. We've got a great team of 6 paralegals, non-attorney staff, in addition to ourselves here in Denver. We're handling these cases on a regular basis. To the extent that you have questions, feel free to reach out. Last thing I'll mention here, in terms of follow-up, you'll be getting an email. I know many of you care about the SHRM credit as well as the CLE credit. So this has already been approved for CLE credit in Colorado and Utah. It's been approved for SHRM credit. So anyways, that information will follow. We are also attaching some information, just kind of like an FAQ document. It's called the H-1B lottery summary. So to the extent that you want to kind of read through some written materials, we've provided those as well, just in terms of common questions regarding the H-1B process. That might be something to share with the immigrant employees that you're working with. We also have provided an intake questionnaire in case you'd like us to assist you within the H-1B lottery process. Anyways, we need you to complete that intake questionnaire. We actually had the deadline for those questionnaires on the last day of January here. We're past that, but anyways, to the extent that you have any cases you'd like us to assist with, let us know as quickly as you can. I think that is it. We will stick around for maybe another minute or two just to see if there's any questions. Thanks for those who have stayed until the very end here. Sarah, any other questions or any other issues you want to mention?
The only thing that we didn't cover, which I can touch on briefly, is that we had stated early on that the filing fees are potentially going to increase for many of the immigrant or non-immigrant petitions. That is the case. In January of this year, USCIS published a proposed rule to increase filing fees. And if implemented, the fees for employment-based cases would increase substantially. For example, H-1B cap registration could go from $10 to $215 per registration. And there's going to be possibly a $600 asylum program fee added to every I-129 petition, which would be all H-1Bs and some other cases, and every I-140. And the base filing fee for the I-129 would go from $460 to $780. So some pretty substantial potential increases, but they won't impact this year's H-1B cap selections because the changes, if they occur, would not happen until after April of this year. So we'll continue to monitor that, but it looks like those fees could increase somewhat.
Perfect. Thank you so much for that context. Let's see, we will stick around here for just another minute or two. Once again, if you've got any questions, feel free to add them to the chat box.
I think we received another question regarding whether we work with companies such as schools that are not part of the lottery. And yes, we absolutely do. We have already some clients that are H-1B cap exempt and not subject to the lottery. So that's something we could certainly help with if there are other individuals listening that are in cap exempt institutions such as schools or hospitals.
Great. Well, thank you all for your time. Once again, there'll be that follow-up email, and yeah, feel free to reach out to us if you have any additional questions. Take care.